This is Halleck Hoffman speaking from the Center for the Study of Democratic Institutions in Santa Barbara. The center was established by the Fund for the Republic to study whether and how a free and just society may be maintained under the strikingly new political, social, economic, and technological conditions of the 20th century. Robert M. Hutchins, chairman of the center, recently described to an audience the center's method of study through dialogue and discussion as follows.
The Center for the Study of Democratic Institutions is a group of men meeting continuously and trying to think, I will not say how successfully, about the most urgent problems which, in their opinion, now confront us. The purpose of the organization is not merely to think, not merely to try to think together, not merely to offer a model of an intellectual community, or to suggest how the dialogue may be carried on and the civilization of the dialogue achieved. The purpose of the center is to try to clarify the most important issues that we now face and to try to get these issues discussed by those who may in some way or other determine what shall be done about them. Every day at 11 o'clock, one of the staff or a visitor, of whom we have some 300 during the year from all over the world, is required to present a statement, is required to subject himself to cross-examination, and then he's required to go out and think it over. We do believe that we confront a totally new world. We believe that the rate of change is unexampled. We believe that it is only by taking thought that we may hope to save the West and perpetuate those ideals of freedom and justice to which we are all dedicated.
During 1963, the entire summer was devoted to the center's continuing study of law, jurisprudence, and the Bill of Rights. The broadcast that follows is the third of 4 seminars held to consider a theory of the First Amendment proposed by Joseph Tussman, professor of philosophy at the University of California at Berkeley. Mr. Tussman, who is preparing a book on the subject, tentatively titled The Government of the Mind, suggests a theory that reads the First Amendment as protecting and encouraging the active participation of the citizen in political affairs. Since government already assumes responsibility for protecting the body of the citizen, as through pure food and drug laws, weights and measures specifications, and so on, why, asks Mr. Tussman, should it not also assume similar responsibility for protecting the moral and intellectual development of the mind? In the same sense that officials like congressmen are guaranteed access to forums and are protected from the consequences of speech, so too, argues Mr. Tussman, should the citizen be offered protected opportunities for communication. Pursuing the analogy, Mr. Tussman then concludes that having thus immunized the citizen from the consequences of his speech, the government would have the right to inquire into the state of his mind or thinking, where such inquiry serves a public function. In the meeting preceding the one that follows, Mr. Tussman had defined speech as aggressive in character and therefore, because aggressive, subject to regulation. In this discussion, the third in the series, Mr. Tussman will be heard modifying his definition of speech as aggressive activity. Here, as he begins the third meeting, he reminds the staff that while traditionally freedom of speech implies also the freedom not to speak, the right to silence is not absolute. It is not guaranteed to the witness of a crime when he is called upon to testify, or to the candidate for office, as well as in many other situations where the common good demands that citizens reveal their thinking. Although many participants were sympathetic to Mr. Tussman's proposition in general, there was sharp dissent on the particulars. Participating in the discussion are the chairman, Robert M. Hutchins, Alexander Meiklejohn, former president of Amherst College, Harry Calvin, Jr. of the University of Chicago Law School, Judge Edwin Dunaway, former Supreme Court Justice of the state of Arkansas, and staff members Richard Lichtman, W.H. Ferry, Harry Ashmore, Harvey Wheeler, and William Gorman. And now, Mr. Tussman.
I don't think we can start with an absolute right of silence. I don't know what we would think of a Supreme Court which said, in effect, we'll give you our decisions, but our opinions are our own business. We require that the court display its mind and reveal its beliefs. And there may be other situations and offices in which that is an important part of it. So I find it difficult to start with the notion that there is an absolute right of silence in all situations. Now, there are problems of relevance as one tries to see what sense you can make out of disclosure of one's beliefs and opinions. We do make demands of relevance. What is disclosed must be relevant to the situation. The second qualification is that the disclosure must be accompanied by some protection from the consequences of it. That is, and we have a wide variety of immunity statutes, for instance, ways of immunizing that kind of disclosure under the name of privilege, really, as I mentioned last time. And a third qualification, apart from relevance and the protection against some consequences, that the disclosure, the required disclosure, must not imperil the essential privileges of some other situations. And I formulate this way in order to at least bring up the question of if it's necessary for a person to disclose his political beliefs in order to pass the requirements of the bar committee about whether he's admissible as a lawyer, to be admitted as a lawyer, the bearing of this on his privilege as a member of the electorate to pursue the truth as he sees it in his political discussions and so forth might very well be threatened. And one of the problems is, how do you reconcile what seems to be a legitimate demand about probing into his qualifications with the necessary protections of another privileged situation? In this connection, I just mention again, it would seem to me, in terms of the situations which justify the probing into opinions in the mind, I've always been troubled by the situation in which one applies for membership in the body politic as for naturalization. There have been some interesting situations in which the court has said, if you want to join you want to be a citizen of the United States, do you understand the Constitution? Do you agree to abide by it? Do you have any mental reservations? Would you, if necessary, discharge your obligations? There have been some interesting cases about old ladies who have been pacifists who were reluctant to bear arms, and Yale theologians who wanted to reserve a higher allegiance to God. But the point is, I find it very hard to say it's not the business of the political community, as it determines the qualifications for membership, to say that the state of this person's mind is not at all relevant. And even the requirement that he make a public commitment and declaration of his acceptance of certain moral obligations, whether he's going to abide by them or not, I think is I don't know what involved there, but I find it very reasonable, and I think the phoebic oath thing is not altogether abhorrent as a notion. Now, so there's the problem of admission of new citizens. I think this spills over into the problem of the legitimacy of occasionally seeing whether the status of citizen or some of the rights which are provided to citizens are not forfeited by disaffection or by a change in attitude, so that the whole attempts of loyalty probing or the redeclaration, really, of the commitment seems to me finds the popular justification that it seems to have in the demand that the enjoyment of the rights of membership are conditioned upon the acceptance, the intellectual and moral commitment to something. And the community might have a legitimate interest in seeing whether or not those conditions no longer hold with respect to an individual, and as a result, he forfeits his claim to what follows from that commitment. I don't like this at all, I admit, but at this point, I think one has to face the question which is raised not only at the point of admission, but the legitimacy of a continual seeing of whether, in some sense, this very odd relationship of membership in a body politic, in a significant sense, isn't affected by a change of mind. And as a matter of fact, it has been very difficult for people who oppose the whole loyalty oath business to come up with a decent argument, come up with something besides a cliche that doesn't really touch the issue, I think, as it needs to be. But I'm not going to solve that right now. Dr. Mickeljan and I once had an inconclusive discussion on what sort of questions it's legitimate to ask of a candidate who's been recommended by the President for a Supreme Court position. What can a Senate committee ask him legitimately as it begins to decide his fitness? For instance, everybody would agree that they ought not to ask him how he's going to rule if he's appointed on the case which has just come up. But can you ask him his conception of his judicial task? Can you say, do you believe that are there absolutes, or does everything have to be balanced? And is the Constitution law in the ordinary sense, or is it an interesting historical scar which our history has thrown up, which serves as an admonition. Do you believe in judicial self-restraint? Do you think you have a duty that you ought to perform without restraint? I mean, are these questions which it's legitimate to ask? Now, the reason I raise this, it seems to me that they are, and I'm a little taken aback, and I've learned to take being taken aback in this way seriously by the fact that Dr. Meiklejohn has some doubts about the legitimacy, I think, of some of those questions, or perhaps all of them. And the kind of inquiry you engage in when it's for teachers again, you're concerned with the balance of the department. So you want an atheist or you want a Catholic, and you got to go looking for them. You've got to ask people, is it legitimate to inquire into his beliefs and whether he thinks he's going to be a communist long? Because if he's not, if he's on the verge of leaving, I'm sorry, we need a convinced one. Are these questions? How do you deal with these? Apart from indirect ways, there may be now a tactic of direct and indirect ways of doing this, but so far as I can see, I can't see a principle at this point which justifies the view that this is a matter of opinion and no one can ask, even when I'm making myself available for a special function which requires a good deal of trust, that I can't be required to reveal that. That does not seem to me to be initially plausible as a view, although we may develop all sorts of wise policies with respect to that very complicated situation. But I'm unwilling at this point to start with, seems to me we can't, with an absolute right of non-disclosure for a wide variety of situations. Well, I'm going to leave that unresolved and just mention that there, with respect to the notion of privilege, I've mentioned the protection of individuals from consequences of his activity. It's obvious that we can't protect people from the entire range of consequences. We can protect a person from, if he says something under some situations, from having to have inferences. For instance, take the Fifth Amendment situation. What are the consequences against which we can protect somebody if he takes the Fifth Amendment in the Senate? We can protect him if he takes the Fifth in court from, let's say, try to protect him against an improper inference that the taking of this is itself an admission of, can be taken as an indication of guilt. Can we keep other tribunals from taking this as an indication of something wrong that shifts the burden of proof or raises a legitimate question that needs further inquiry? Can we prevent perfectly private drawing of inferences about where there's smoke, there's fire, and all sorts of things based on it, which may have very concrete effects for the person if he's in a position which requires goodwill, public relations, all this sort of thing. It's impossible to protect him against this. And there is a natural price, I think, inevitable price one has to pay for positions. But there is some rhetoric even in the Supreme Court occasionally about heroism. I don't think one has to, if we come to the point where one has to be a hero to make a speech, I think one then has to begin to worry about whether we're going to get the kind of criticism we need, because sometimes we have very important but timid critics. So I think just there are consequences, yes, but one ought not to have to be a hero in order to enter into the necessary critical life of the community. Now, in terms of the protections which further the life of criticism, I suppose one of the cases that's made for free enterprise, which I haven't touched on and which I'm generally opposed to in every respect, but didn't want to drag in as an additional burden at this point, before now, one of the cases that's made for free enterprise in the communications industry is that it does create centers of independence and power which can be used for criticism. And I would suppose if there is a justification for large respect for an independently rooted communications interest, it's that it provides the kind of countervailing, some kind of assurance that there will be independent criticism. I think the record is quite clear that to my mind, it hasn't provided that adequately, but even if it provides that in some measure, it has not provided for a satisfactory total communication life, so far as I can see. Another word about something I've stressed, which I think I've been reminded, especially by Mr. Gorman, rather wisely, and I appreciate it, that I've been stressing the aggressive character of communication, or that aspect of it which is aggressive. And I guess I have to remind myself, and say that I'm aware now, certainly, that there's something built into the notion of communication which is essentially non-aggressive and competitive. It is the notion of communion, or community, or of communing, and that to see communication entirely in terms of the hurling of one body against another and manipulation is fundamentally to misunderstand the whole conception of language. So I do want to, just in passing, say here that one of the ways of judging a good system of communication, that is, whether we've succeeded in creating a satisfactory system of protected opportunities for discussion, is in the end not how many occasions and what are the specific protections, but once you've dealt with the problem of aggressive uses of these in the wide variety of ways I dealt with last time, whether in fact the communication life of that society is enhancing the peace and the creation of a community. One other thing about the arts and science. Now, and in connection with this, I may be anticipating, or at least setting the stage again for an argument that I know there are some interest in making. There are two justifications for the freedom of communication activity. One rests on the notion of function. That is, we justify giving of scope, freedom, opportunity, and protection to some kind of activity because it is necessary to have that in order to perform the function which we want performed by it. It's necessary to give a congressman the right to speak and to read and to hear and to argue and to be free, because without that we feel that legislation won't be produced properly, it won't be wise. So that the functional justification is one thing, but now there is all, suppose one says with respect to, this doesn't carry you the whole way. Art, for instance. One can give a functional justification for the freedom of the arts, which I would suppose is something like this, that we need to license a whole group of individuals to put things to us in a different way, to begin to break up patterns of language and symbolic representation, and to make us suddenly see what is familiar in a new light, and to experiment with other possibilities. And we need people to do this, so that the justification for the freedom of the artist is that these are the people who kind of are working on the periphery to alter our view. But suppose you say that isn't enough, because what we have here really, art is valuable not only instrumentally in this sense, but for its own sake. That is, it's an end in itself. I would suppose you say art for art's sake, it's an end in itself. It's pursued because of another interest, and perhaps only performs its other function if it is pursued with this other dominant motive for its own sake. I would say, suppose you grant that, and I do grant that. It does not follow from the fact that art is pursued for its own sake or intrinsically valuable that it enjoys unlimited freedom. The question of its claim to freedom, where it has consequences, has to be made independently of the fact that it's an intrinsic good, because there are a great many intrinsic goods. So that I would say that this same thing holds, I think, although I don't want to go into this, for the cognitive enterprise, the freedom of the scientist, the freedom of research. We say on the one hand, well, you need it for this, that, the community needs it to make wise decisions, to solve its problems and all of this, and then, true enough. Then there's another, but what about the pursuit of truth as an end in itself, and a good in itself, and all this? And I would argue here that, yes, it is, but because we pursue knowledge for its own sake doesn't mean that it's immune to the kind of controls which might be necessary when that pursuit gets harmful. I don't know whether in principle a general moratorium on certain kinds of research until we're ready for it to handle its fruits, a kind of spiritual Luddism, I'm afraid, is altogether unreasonable in some situations. But I would say furthermore on this that I reject wholeheartedly the conception that life is an experiment. It's not an experiment. It's a terrible figure of speech. Or if it is an experiment, we're not the experimenters at any rate. And the notion that the object of life is somehow to do things with ourselves and people so that we find something out, seems to me is a terribly warped and silly view of the human condition. Now, I distinguish between the functional and the intrinsic justification for freedom, and I would put this over to the individual. As we justify an individual's freedom in any situation, we partly justify it because he's performing a function. That is, it's the freedom which we give him because it's necessary for the performance of his function. On the other hand, we say, how about the individual as an end in himself, his own sake, and all of that sort of thing? I say, yes, he is an end in himself and all this, but this does not by itself justify the notion that he is not, in a world in which there are other individuals also, free to express himself without limit any more than art or science. Well, with that, and with a feeling of real gratitude for your patience over the last 3 days, I throw it open, and I now promise to listen to the questions.
Take the cases of labeling, for which I think you made the strongest cases. One, the labeling of a product, for instance, the ingredients of a product. Two, the labeling of a speaker, for instance, the individual who lobbies on behalf of a given cause and who is otherwise unknown to us. And three, the forced testimony in some sense of a witness in a tribunal, a court of law. Now, in these cases, and I think this touches strongly on the problem of loyalty, These functions of labeling are in some sense preconditions for the establishment of objectivity. Let us take the case of the witness. If you want to discover what the truth is in a trial, you require that individuals come together in a certain manner in order to pool their resources to make this discovery. That's not so very different, in other words, from the whole problem of the rules by which a meeting is conducted, like Robert's Rules of Order. Here you have a set of preconditions which have to be fulfilled in order to have a process by which you arrive at the truth. In the case of labeling the product, part of the justification would undoubtedly be that the overwhelming majority of the citizenry is incapable of its own in determining whether a given product, for example, possesses a given ingredient. That, for me, that tends to take care of one sort of the thing, one sort of the problem. When that breaks down, when, for example, as you pointed out, I could bring a scale to a supermarket and weigh the product and therefore don't really need an expert, the fact is I think we grant that because of the nuisance value involved in bringing scales and because of the fairly explicit agreement about the objectivity of that which we're trying to discover. That is, a product either weighs 10 ounces or it doesn't weigh 10 ounces, and it's not a relevant issue of great dispute. Now, when you get into the problem of labeling the speaker, I wouldn't want a speaker labeled for any purpose in which I thought I had a certain general competence in arriving at the truth. In other words, I want to investigate the problem on its own and not in terms of the genetic source of the point. Now, the problem about loyalty seems to me to fit in here because, you see, the labeling provides, as I see it, a function in terms of establishing the conditions of objectivity. But the great difficulty about loyalty, whatever the cliches have been, is in filling out the last phrase, loyalty to. Now, loyalty to what? The whole dilemma in establishing loyalty to what is in filling in that term. When you come to that term, you have a term which, as a matter of fact, is indeterminate in its character because the whole interest in a dispute is to find out what the loyalty is to. If I could discover the loyalty, in other words, to an objective case like how much the product weighs 10 ounces, there would be no great dispute, I suppose, in signing a loyalty oath saying I weighed this and it weighed 10 ounces. But if I have to discover loyalty to a country and define that loyalty, that is one of the conditions of the debate which one hopes will come out of the debate and not be defined prior to the debate. The same thing with loyalty of a teacher. What a teacher is one of the great functions of the debate to discover. In other words, there's no clear definition, which is in any sense in the objective category of weighing 10 ounces, which will define the function of a teacher. To know what the function of a teacher is, one has to involve oneself in the debate. I don't think I would be satisfied that anybody has laid down a definition of a teacher which is exhaustive, complete, objective, and which obligates everybody to accept it. Now, I'm belaboring this point perhaps, but I'm trying to mark off the distinction between an area in which the conditions are fairly simple and objective, and one in which dispute is part of the very nature of the problem. And the loyalty, the whole problem of loyalty against forced compelling is exactly, I think, this difference between an objective situation and one of which the truth has to emerge from the competition of ideas in a marketplace. That was the first general problem I would put.
Am I to answer?
Well, I don't know. Answer.
Well, I mean, there are a number of different things. The problems on the labeling. I think some of the questions are different. The labeling. I start with the notion that there are many situations in which we can relieve a person of some of the chores, like weighing the pen and deciding whether there's a preservative, guaranteeing of truth, but labeling of special interests in situations in which it's relevant to a person's evaluation of the testimony. I take this for granted and have pointed to this as a question that we have to re-examine, where we're reluctant to. But I'm also interested in the intersection of this demand for labeling with the effect it has on the necessary protective privacy. That is, to be labeled in all situations in which you have to speak may, if you have certain views, require that you be a hero to speak, which is something we don't want. So that, although it might be useful to me to know that so-and-so is a Marxist, if he can only speak if he says he's a Marxist, and if being a Marxist means that he isn't going to earn a living, I'm not going to hear Marxists talk often enough. So the demand that you label the thing has to be at least considered in the light of this other problem. Now,
I recognize that problem. The problem I'm discussing is the objective character of the product to be labeled. When a man has to announce his loyalty,
I think in my presentation,
something is being labeled that's quite different than, I think, in another category from the labeling of a product.
Yeah, I don't regard the loyalty question as a labeling one, but as a question, I raised it in connection with the question of whether it's legitimate to consider a particular state of mind as a precondition of the enjoyment of certain rights. It's analogous to the notion of no one can play this game unless he agrees to abide by the rules.
All right, now my question is simply, what is the character of the rules? Is there an objective procedure upon which one can decide for agreeing upon what the rules are?
Well, I think in some situations, yes. A person who wants to take part in a caucus, if you admit somebody to a caucus to agree on a candidate that you're all going to support, one of the rules of that game is whatever the caucus decides, I'm morally obliged to support.
I think
And
there
if
was-
and you can ask for, and the Democratic Convention has always had this fight about it, are we going to ask for a loyalty oath, in effect, because at this point, some people are claiming that they have a right to take part in a caucus and not recognize the rule that they're bound by the result. Now, I think the inquiry into that state of mind, before I admit somebody into my caucus, namely, do you understand that we're getting together? I may find myself bound to support a candidate I don't want, and you may too, but that the whole purpose of this is that we all agree and understand this, that whoever we agree to support, the majority, we're all bound to do so. This is a state of mind and a commitment. Now, the expression of this, the attempt to make it clear that everybody at least understands this, and gives indication of this by having to say, yes, I do understand this and agree to it, whatever else he's going to do afterwards, doesn't seem to me to be illegitimate or very difficult in theory.
Talk a bit about the Supreme Court. A man proposed for appointment to the Supreme Court, trying to pass through this particular course that you just described, Joe. The state of mind, is it appropriate to require of him his state of mind about the Brown decision? And if you say it's appropriate, if you say it's all right to ask him about this, it's necessary to ask him, what if he answers in the way Southern justices have answered? We think the Brown decision is a bad decision, it was untimely and so on. Of course, we'll uphold it because the Supreme Court has spoken.
At this point, I find it hard to see anything wrong with that. I find it hard to see anything wrong with, if your responsibility is to, here you're going to appoint a man to the Supreme Court. The President has said, I offer this as your candidate. It's your function to advise and consent if you think it proper. What am I supposed to do if I'm a senator and here is this man? Am I supposed to say, how many children do you have? And I like your blue eyes, or not? Or am I supposed to say, being careful not to put him in a position of having to give a concrete judgment that might, as a matter of fact, prejudice his capacity or dealing with it? Am I supposed to say, what is the quality of your legal mind? What kind of attitude do you have? As revealed by something. Of course, I haven't got the, I'd like some help on this one.
Go a little bit further. Let's grant that. Let's grant that the prospective appointee is before you and he says, yes, I have these views about Brown. We'll admit the appropriateness of the questions. Now, what are the senators supposed to make of an answer of the kind that I have given? Does this say that the man is qualified or disqualified?
As far as I can see,
it's got
that
to
has
have
no
a
bearing on
purpose.
his qualifications.
Well,
A
why
man
ask him
says
that?
that he thinks the Brown case is a terrible case, but as a judge he would defer to it so far as one has to defer to a bad case, and that isn't very far. It seems to me that's a perfectly legitimate sort of thing. He may think that Plessy was a bad case, or the Dred Scott thing, or the
Did you
Smith
say it was irrelevant to his qualifications?
The attempt.
Maybe I've asked the wrong
I would be
question.
far more interested in not whether he is for or against the Brown case, but if I would ask that question, I'd be interested in the quality of his mind as revealed by his attempt to explain what was involved.
Well, I think I like your last answer, Joe, but there really is a paradox here that partly derives from the fact we don't know what we want in a judge, so the part of the problem is not one that properly, I think, is on your shoulders at the moment. But it seems to me that one of the difficulties with the line you're taking, and I think Ping is in a way pursuing this, is that whichever way the question is answered, you're embarrassed by drawing any consequences from it. It seems to me, suppose you ask him your better question, you say, well, how does he feel about judicial self-restraint? So he's either for it or against it, or he has no opinion about it. Now take any one of those three possibilities and make a judgment about him as a judge. It seems to me you're in difficulty. In a sense, questions that appear to be relevant really are not relevant, unless in some gestalt way you're going to use all of the talk he gives you over 2 hours as some way of, you're saying, well, it isn't just his view on self-restraint, but the whole 2 hours with him is somehow give me an intuitive sense about him that I'm relying on.
But what goes on? Look, you believe in self-restraint. You mean you ought not to perform your function? Or you ought to restrain yourself from doing what it isn't your function to do? I think there's some cross-examination that goes on. What should you restrain yourself from doing? From enforcing the Constitution?
But give the kind of answer he would give that would make it a relevant basis for disqualifying. I mean, what would be a possible answer?
Well, now, disqualifying.
I mean, you would rationally vote no against him because of the answer to that question.
I would find that if I were in the Senate, I don't know, please, I don't want to be held responsible for this for all time, but if I were in the Senate,
Well,
the
let me
judge
give you a
came
6-year
along
term
at this
in the
point and I said, what do you think of the Constitution? And he says, I think it's an interesting set of admonitions, and that as a matter of fact, the voice of the people is expressed not by in the Constitution, but by the legislature. They've been elected. I don't think the court ought to interfere with them. I think a good craftsman can always find reasons for throwing out any appeal from a thing. The real defense of liberties is in the hearts of men and all and the goodwill of the majority.
So now he's quoting Lernerhand, Thayer, and Frankfurter.
And I would vote against them.
Well, you wouldn't really.
I sure would.
Well, then I think you've boxed yourself into an impossible.
I would. I'd probably be outvoted, but but now, vote against. In my mind, this would be, unless there were. Let's see.
But are you voting against? Are you voting against Frankfurter and Thayer, or are you just voting against the guy who answers?
I think Frankfurter is a bad judge. I think he's been a disaster on the Supreme Court. And if I could have known that, well, what am I supposed to be voting on then?
Well, that's a great mystery. I agree.
I'm a little.
But I would be shocked. I mean, to be absolutely candid, I would be shocked at the idea of voting against Frankfurter on the basis of even his performance since he became a judge.
I would vote for him on the grounds that they always need somebody like that around, probably. But I'd want to.
I want to get back to the question of privilege. If you're through with this, I think it's off this subject. I haven't understood the weight you give to this question of privilege, and I ask this as much for information as anything else. It seems to me that, effectively speaking, privilege that's extended to elected officials and, say, courts, both, embodies in it a protection for me as a defendant or an individual, which is quite important, and it seems to me virtually offsets any real privilege that may attend to the person who's exercising it. It extends it in this way. It requires, in response for the immunity, to specific penalty for the utterance, a requirement that the utterance and the action and the deliberation of the court be made wholly public, made for the record, and that is a considerable protection for me as an elector or a defendant in the case of a court case. In the matter of an elected official, you made the comparison yesterday between the elector and his risk and the congressman. In the case of an elected official, it seems to me that he has no real effective immunity. The only time you need this protection, of course, is when you're espousing an unpopular position. It's at that point that an elector suffers some kind of penalty, economic consequences or otherwise. It seems to me as a generality that the elected official at least runs the same risk. If he espouses an unpopular position, he's going to suffer the very heavy penalty of losing his position. He's going to be voted out when the time comes. The only people who seem to me to have any genuine and special privilege or immunity are the judiciary, the lifetime appointment, where they may take publicly unpopular positions and be virtually immune personally from any drastic consequence. They can continue to be judges. And that raises the question of how you get to this notion of extending special protections to electors without doing a considerable violence to the whole democratic theory. Now, the fact that some protections are needed, I would admit, but if you take this very far, don't you have to, in effect, take these people out and give them the kind of immunity from the democratic process that we accord deliberately to judges for other purposes?
I think not. I think you and I are members of the electorate. In order to discharge our function, we have to have the power, access to the relevant information that shapes our judgment, that's relevant to the shaping of our judgment. We have to have the opportunity to engage in the kind of discussion and reflection and criticism and debate, which is a necessary part of our making together a basic governmental decision. So that in the first place there's a kind of empowering to study. And the force of this is that I don't think a postal official has the right to decide that reading a particular magazine is going to be bad for me and he doesn't like the way it might affect my mind. This whole line of argument, that there's none of my servants here is going to tell me what I can protect my mind against bad ideas, things of this sort. But the other side of it is I then express my judgment, and among the protections we provide is the secret ballot. It was perfectly possible not to have it, and in the early days we didn't. You got up and said, and we decided, I think wisely, that at that point, because people are subject to all sorts of retribution, we want their honest judgment. Although John Stuart Mill, I'm always intrigued by the fact that he was very worried about the secret ballot. And his argument was, voting is the act of a public official. Like public business, it ought to be done in public. And to make it a private matter is going to confuse people. They're going to think they're entitled to vote for their own interests. And he said only in a situation where the significant fear of private retribution due to a disparity of power, such as where the employer might fire you or things of this sort, were you justified in providing that protection. Rather interesting idea, but I think we need some protection. Now, in order to engage in discussion In order to go to meetings, in my quest, for instance, for the kind of information I think needed for me to perform my function as a critic, I may want to go to Up House's meeting and hear some returnees from Cuba. I may want to subscribe to Pravda. I may want to hang around with people who are thoroughly disaffected. I may want to join a Marxist study group. I may want to, in short, end up on all of these lists of people who hang around with suspicious characters. Now, I may also want to read and say things which I think communicate with others in my discussion, things which are highly critical. Now, suppose I am before a congressional committee called to answer for that, and my political behavior of this sort is made public, and that I have to say, was I here, did I believe this, did I say this? What's wrong with this, for instance? Well, I think the problem of privilege comes to the fore here. To require me to reveal publicly in forms that I don't myself choose, let's say, my political beliefs, my communications, my associations, is in fact to put the kind of pressure on me that prevents my performing my function. And the privilege that I don't have to answer for my political communication, I don't have to account for it to anybody, is the significant notion of the privilege that I think we as electors have.
Well, I agree with you to the point that there are gross abuses in the committee function of Congress and this listing. But to me, that is a relatively minor and separate question from the larger issue I'm trying to raise. Leave all that out. How far are you going to take this extension of protection? Suppose, in order to further my view, which is unpopular, I'm going to utter it on my own terms, and as a result of this utterance, I'm going to suffer some penalty.
Yes.
Does the government have any objection to protect me against that penalty, which is a purely private action on the part of my fellow citizens? The government is not involved in it.
How about protection against systematic boycotts as a result of this?
Well, that's what I'm asking you. I don't see how you do this.
I don't know how you can, I think you can't immunize them against all
I'm asking
forms.
you really not to get into the details of how you do it, but take the instance I just cited where the government is not involved. I have not been exposed as a result of any government action.
I know.
I am now, nevertheless, suffering penalties.
To some
economic
extent.
penalties. Now, does the government, in your view, have an obligation to extend some protection to me here?
I think it would be a good idea if the government could figure out ways of doing it, but I don't know what they are without, you see, and partly, I think the more we understand this process, the more we will be inclined not to visit this kind of penalty. I had a very interesting experience. It shocked me a lot, and I may tell you briefly about it. In the town which I was teaching last year, I went to a particular barber who was a local eccentric character with a wide variety of offbeat views, highly ethnocentric type, but I kept going. He didn't give good haircuts, but I got in the habit of doing it. He was my barber, and I'd come there and he'd talk about all sorts of things. Late in the game, I discovered that he refused to cut difficult hair or charge $50 to give a boy from Tuskegee who was visiting a haircut. I mean, it was known that he didn't. And the legal aspects of this had not yet been worked out. He was a barber. He didn't want to cut Negro hair. He had a lot of crotchets, and that was one of them. And then at one point, since this had gotten out in some student publication which had not quite effectively been suppressed or pulled out on account of libel, he was suddenly suing the university for libeling by saying that Mr. X not only gives terrible haircuts, but he won't cut Negro hair, and this was to guide freshmen and orient them. And sue them for libel. And as I sat around the faculty table discussing this, I heard a lot of very strong, virtuous feelings. Well, I guess I'll stop going to Mr. X. And this would have been my normal reaction. And suddenly the image of this pathetic barber, this poor kind of guy up there waiting patiently behind his chair to cut my hair, I thought, am I supposed to now penalize him for the honest expression of his views on an issue in which he was not doing anything as yet illegal, and deprive him of his livelihood? The result is I kept going to him, getting bad haircuts, and some more interesting conversation. But it seemed to me to illustrate the fact that you can't rely on government entirely. If we genuinely believe in the freedom of political discussion, I would suppose that if a man is a genuine segregationist and gets up and makes a speech to the effect that he thinks segregation is a good thing and ought to be maintained, that people ought not to stop buying their ties from him because of that.
I used to say that about newspapers, too, but one more point before we leave this, because I'm really trying to get clear your view. I would state this in terms of an objection. It seems to me that you're stretching the analogy of the secret ballot too far. The secrecy of the ballot is a pretty limited act. And when you get into the question of attempting to influence public opinion, say, carry a cause by taking it to the public, don't you necessarily yield some of your rights of privacy in the same way that a public official is expected to when he declares himself for office? If I become an advocate for a cause, don't I expose myself in a way that I certainly would not expose myself simply by casting my ballot?
I think that's
and
right.
Therefore, yielding up certain of my...
Right, but Harry, I think the point I made is that we ought not to carry it to this point where to make a public speech requires that you be a hero.
Well, I agree with that in theory, and I don't want to belabor the practice in which you're going to protect it, but it seems to me that you're getting to a question of essential democratic theory pretty fast.
But it seems to me, if I may have one more word on that, the democratic theory requires serious efforts to protect the entrance into the public forum and the public discussion by trying to shield, so far as we can, I don't know how we can, the individual from the sanctions which are the result of his deliberately doing his duty as a member of the sovereign.
But if you applied your bad haircut principle, you would absolutely bog down the Negro race movement at the moment, because this is the only real weapon.
Well, I don't know. There's a difference between not buying at somebody's store because he won't sell to somebody, which is one thing, and not buying at his store because he thinks that there ought to be segregation and says this as a matter of his public opinion.
This is a bad example, because if you use a political principle in engaging in an economic practice, in a business practice, and that, I'm not sure that it's a clear free speech
I
proposition.
think Harry wanted to say something, and then Judge Dunham, and then Bill Gorman's trying to speak here.
I've got two reactions to this last bit of discussion that probably are inconsistent. I want to charge Joe with being inconsistent by making them. First, I think I agree with, I think we all would have to, that you can't carry the supportive government notion so far as to guarantee the speaker an audience. I mean, it seems to me the simplest act of disaffection or censorship is the audience walks out, or they don't read him again, or something like that. I mean, you can't. There's a problem about dissociating that act of critical disapproval of what he said from anything beyond that I think gets tricky. But it seems to me more interesting, Joe, it seems to me that there are difficulties now with your principle of compulsory disclosure, as you stated, that you've almost taken it back. And let me argue it this way. I take it that you would say that the state has an obligation, if it's going to compel disclosure, to protect from the consequences. I mean, that was
some of them, at least.
Yeah. Now, is it entitled to compel disclosure if it's unable to protect from the consequences?
I don't know.
It seems to me that's in fact been the phenomenon we've had experience with. The state has either been unable or unwilling. It's compelled disclosure knowing that the consequences would be very strong in your terms.
We've had it even further, that sometimes the disclosure has been required precisely for the purpose.
Yes, and in fact the state might appear to be the generator of the consequences almost in terms of
I see. There are consequences you can protect a person from. You can immunize them against being tried in the court. I mean, if you testify under this immunity, we can't prosecute you for any of the crimes that have been revealed that you've done, for instance.
But it seems to me most instances in which you would want to require disclosure from someone who on hypothesis does not want to make it would in fact involve a situation in which something unpleasant for him will happen as a result of the disclosure, otherwise he'd be making it voluntarily.
Well, let me say, Harry, that to the extent that there's a bona fide reason for getting the information, the possibility of an executive session here, that is,
The question of the impeachment of the veracity of a witness is perhaps a better case. What are the limits on the impeachment of the veracity of a witness?
You're asking me?
Yeah.
You're the expert on evidence, I will tell you.
Well, they're very wide limits, as long as it can be argued that the evidence sought for does in some way show that he's a habitual liar or a liar in this case.
But it seems to me that principle taken out of the courtroom becomes very puzzling, doesn't it? Any use I can think of the principle there's some propriety in compulsory disclosure of the kind we've been talking about, which is in sort of in the public forum, seems to me to run afoul of another principle you set up to safeguard this one, that the disclosure won't have attended the consequences which the state can't protect the man from. And in fact, the game is likely to come out always as being the other way around. The state will compel the disclosure, it will produce the consequences, and in fact there will be an extra sanction added to the situation beyond what you apparently would intend in setting it up.
I don't suppose you can protect them from all, but look, and I haven't the answer to this. All I'm concerned with here is that I don't find at hand a valid principle that protects against disclosure in all circumstances, and that I see this as a problem that has to be worked out. What I'm trying to do here, in a sense, is map the area of the problems, and at the moment, it's beyond me to solve this or that particular one, but some of our answers have been unsatisfactory in this area. I can't go along with some of the rejection of the demand that you testify under certain circumstances when the argument is that I don't have to say anything that I don't want to say, as if there's some sort of absolute principle of privacy beyond the wisdom of maintaining a system of non-compulsory disclosure. And I think we're badly in need of some understanding of at least what the major problems are. Now, I see this as a clash between a legitimate need for the information and the inevitability of some consequences which are harmful to the individual, and the limited capacity to protect a person from all of the consequences. So we protect them against some of the range of consequences, and then what about the rest? I don't see how you can. I don't think in the nature of the case you will ever be able to protect a person against all of the consequences of his having a particular position. And I think some courage is needed, and one has to pay a price.
I agree with that, Joe. I was arguing, too, simply that I think your perception at that point almost defeats your endorsement of the idea of compulsory disclosure, because you're going to always have situations in which the one value is going to block out the other.
Well, but see, there's a difference between this is why I mentioned the executive session. If you're saying compulsory disclosure, we really have to know this. The government, some agency of the government, really has to know this. Then I would suppose the principle of protecting this against the newspapers might be a valid one. And it might be that you could get it in executive session where, as a matter of fact, if confidence is not violated, the consequences are cut off. It's only when you talk about compulsory disclosure in a more public sense, for instance, that that problem arises. Isn't it possible to get information and provide relative immunity in executive session?
The income tax returns are an example. I mean, where they're kept highly private. Bob, may I digress for a moment on a reminiscence that's kind of funny in this connection? That we had one congressional investigation in Chicago after you left, surprisingly enough. I think they hadn't quite discovered that they didn't know he was going. But in which they on this particular point about executive sessions, that the particular strategy we were using was to have our witnesses, many of whom were very distinguished, insist on a public hearing where the committee was insisting on hearing him in executive session. I mean, this is the way it worked out. It became quite clear that this protection was for the sake of the committee and not for the sake of the witness. And that we were going to have the witnesses refuse to testify unless they could testify in public. We almost risked having Carlson go to jail on the grounds that he would not testify at executive session, he would testify only in public. And the committee was completely baffled because they had these kind of pious formulas for, this is for the protection of the witness who doesn't want it, and so they couldn't figure out what to do with it.
You know, quite apart from any suggestions I'm going to make, the current state of this doctrine isn't too satisfactory, because what we get here is the notion that the needs of the legislature take precedence over the private desire of an individual not to talk.
Well, this hasn't. Yeah. I had one other. I think you're right. This is a terribly puzzling business, and the institutional ways of handling it are really odd. Because in connection with the jury, again, it is true. If you try and work out what the going rule is, it makes little sense with the jury and with voting. We obviously subscribe to a theory that any degree of disclosure will totally impair the responsible performance of the function. I mean, that's endorsing enormously with everything else, we subscribe to the opposite function, that this is public business, the public's entitled to have, the responsible performances don't go on in secret. The jury seems to have a kind of odd protection from scrutiny.
But not entirely. I've often toyed with the possibility on this point that that the Judiciary Committee would subpoena Warren and ask him who really convinced them that they ought to be unanimous on the Brown case. And they were considering their protections. They're considering altering the appellate jurisdiction of the court, which is clearly within their domain, isn't it? In order to do this, they want to have a clear view about what's going on in those sessions to which nobody's omitted. And this is public business, and it's going on in public. And so we want you, for our legislative purpose, to tell us, did Black say a lot? Did he quote, did he bring into the committee room an article that appeared in the Nation by so-and-so? Did you have a long argument? What would be the answer to that? The answer to that would, first of all, I think it would be quite clear that he wouldn't have to answer, and that he would refuse to answer, and his answer would be exactly this notion of the privileged nature of that communication, whose efficacy, the efficacy of the function, being impaired by having to make it public. And I'm only arguing an analogous case, so far as it is analogous, with the citizenry.
Well, as a matter of fact, the cabinet story that broke some time ago about Stevenson was the same kind of...
Well, I think the executive has claimed this with respect to keeping from legislative committees some of the things in terms just of the separation of powers. In fact, I think this is not a First Amendment problem, following Dr. Micklejohn's line on investigating committees. I think it's entirely a separation of power problem.
I wanted to merely suggest the possibility of the use of the injunction to protect the exercise of unpopular rights as a means readily available. And if I may cite one little instance, we represented the Hoxie School District, which was the first rural school district in the South to desegregate voluntarily. It was going along nicely until Life magazine came out with some pictures about how well it was going, and that ended it. But within 2 weeks then, 60% of the people were out of school, and also telephone calls and whatnot. So, on behalf of the school board, and in violation of the advice of the NAACP and the Justice Department, we insisted on having no Negro plaintiffs, but having only the white school board go in and insist that they had a federally protected right to obey the United States Constitution. So we got an injunction against the White Citizens Council and a list of individuals this long from in any way interfering with the continued lawful desegregation of the schools. Now, Mr. Meiklejohn might think it went a little too far, and frankly, I was a little worried, but it was in a righteous cause. We got them enjoined from holding any meetings, driving by, and incidentally, it was affirmed by the Eighth Circuit. So I'm merely suggesting that there is the possibility, if you got a case that a guy might get an injunction, even in a state court, where they have rules against boycotts for an unlawful purpose, for boycotting them for having expressed a view.
Bill? Mr. Gorman?
I was wondering, I still have some sort of basic questions about the structure of your total theory, and they're sort of hard to get out, but I didn't.
On that point, I'd like to say something. It seems to me that the discussion is quite inadequate. Yeah. Mr. Tussman began with a basic proposition relative to state and society. He went on to the second basic proposition relative to protected opportunities for speech, all in the nature of privilege. If either of these propositions, or certainly if the second one, is ill-founded, I won't say that the conclusions reached on individual cases are necessarily erroneous, but they certainly are questionable. It's suggestive that Mr. Tussman finds certain of his consequences repulsive to himself, which would raise some question about the validity of the total theory.
Or about myself.
Not at all. And it seems to me that in view of the lateness of the hour, that we might give at least one more session of this on Monday if you're free, Joe. Bill?
Well, looking then just only to this Monday session where we might try to get at main outlines of your thought, it seems to me I can give some sense of my opposition usefully if I pick up that part of your remarks this morning, where you said there are two kinds of justifications, perhaps, for the set of privileges that constitute, in your terminology, the system of free speech or free communication. Before I leave it, I think it's not satisfactory to me that the essential constituents of these systems have the legal status of privileges, but that's because I, in my own mature version, am a natural rights man in this area, and I think you are not. And I think a right is different from a privilege in a serious sense. Well, let me get at it this way. The standing tradition, I still think, is a constitutional tradition. And I use for shorthand always, at this point, McIlwain's two constitutional principles. The first, the general one, and the second, the democratic addition. Legal limitations on government is the first principle of constitutionalism, and institutionalizing the accountability of government to the governed is the second. Now, the legal limitations on government, as the first constitutional principle, the right to freedom of speech and the others, or freedom of communication, is a right involving a claim against government, it seems to me. And the essential thrust of your I mean, however you've abused that and turned it into a charter for negative or minimalist government and so on, nevertheless, it still stands as a right against government. Now, I can't get clearly from your thought, well, I do get from your thought the notion that by starting out to saying that all speech, because intrinsically aggressive, though granted you have modified this in your remarks this morning, but yesterday it came out, is regulable, and anything regulable, because aggressive is regulable, and only those forms of speech will be regulable, will be immune from regulation if they have functional justification. Justification to what now? To a standing sovereign body, so far as I can see, whose name is the people and whose instrument is the government. I think there's a basic point of theory there. That's why I bring up natural rights, antecedent rights that are not subject to, except procedurally, to judgment by the standing sovereign people. I don't like the notion of sovereign people. I don't like the whole concept of sovereignty in toto. But I think your theory does involve a sovereign people able to use its government on its own behalf for anything that seems reasonable to it. And that is in defiance of the essential control that the doctrine of natural rights, is, in my view of it, is supposing is sound in reason. Now, I wondered, as we go on Monday, I would like to see whether or not this opposition that I'm making is too sharp or is it right. I have one way of bringing out why I get feelingful about it, because I find, you see, quite inadequate. You're saying, all right, I'll admit something other than a functional justification for these privileges. Maybe there's an intrinsic justification for certain types of activity. Religious, philosophic, scientific, and artistic was my list the other day. Now you said, well, maybe they do have some sort of inner right or claim they're pursuable for themselves apart from what good they do to the state. But it doesn't follow from that, you said this morning, that it has any claim assertable against the state as regards freedom thereof. There appears for me the sovereign people again with respect to these high, if I may say so, spiritual freedoms. I deny that the sovereign people has any right to grant privileges in the area of those four freedoms, because it's not merely that they do involve a claim against the government by the very nature of what those activities are and the objects being pursued and the dignity of the human person involved having an aspiration for pursuits of that high grandeur. There is no competence in political government, given what I take the high purposes of political government to be. However high I put them, I do not include competence to adjudicate how interesting these pursuits are and grant them privileges according to some wise, prudent policies. That power doesn't exist in the people.
Well, we've got a real issue here, because I do
Well, I
take
just
the
wondering
view
whether
that
we
you
do or
characterize
don't.
me as having. I wouldn't characterize a right as a claim against government, but as an appeal to government to give what the government has said it would. That is,
By the way, I don't mean that all rights are claims against government.
all right.
These rights are in the constitutional tradition from
I guess,
which they spring, I think.
yeah, the paradigm of a right, if we start with a very simple case, is a right within a legal system is an appeal to the rules within the system. Now, I guess the question of natural rights is whether there's something analogous to that outside the system of normal, humanly created appeals.
Yes, it's in the structure of reality.
Yeah, I would be very happy.
Quite apart from governmental
I would be
arrangements.
delighted if I could follow you into an acceptance of that. I find it that my own feeble commitment to the pursuit of the truth as I see it makes it impossible for me to take any comfort in the notion that I can't understand really, although I understand that you have it. I can't make myself sense of the notion of natural rights in this sense.
Well, what's very useful to me, in my own thought, I'm asking a question whether the opposition exists, you seem to be saying yes. And what's very useful to me is it seems to me you follow out the implication of the assertion of a sovereign people and the denial of natural rights far more candidly and pertinaciously than is usually done. And to my light, you reveal the deep significance of the error.
Yes, yeah. Mr. Meckle-John.
As usual, I find myself in strong sympathy with the last speaker, except that I don't believe in natural rights. But
You agree with him otherwise.
otherwise.
This is a long-standing kind of agreement we have.
And I have the same uneasiness that I think she's expressing with regard to privilege as the basis, as a basic thing here. And it seems to me Tussman is doing an exceedingly valuable thing in trying to make clear, explicit, and systematic the statement of the things that are not protected by the First Amendment. And that is, if we can get that done, it seems to me we're advancing ever from the loss that began when Mr. Holmes talked about clear and present danger. We've been talking about things that it didn't protect ever since, and doing it, I think, in a very slipshod fashion. Now here we're trying, I think, systematically to make that notion definite and clear and usable. But I object to the notion of privilege as I hear it, particularly as I've heard it discussed this morning, because it seems almost invariably, though not always, but very commonly, to refer to the interest of the person who is protected. It's trying to prevent damage to him. Now you, Joe, have several times said you don't mean that, and yet in this discussion, as far as this discussion goes, apparently the First Amendment is trying to protect the private individual as in terms of his private interest. And that leads us into balancing. That is, I think, the source of the balancing doctrine with all its falsity. Now, the word privilege has a certain suggestion of that, and I've been fooling around in my mind to see if I can find a substitute for it. Now, it doesn't carry with it enough the notion of responsibility. The man's status as a speaker rests upon the fact that as a citizen of the United States, he is a guardian of the public welfare. Now, to describe that simply in terms of privilege, I think invites this misconstruction. So I don't know, I think you're going to find another term.
I thought you had just found it.
You think privilege does it?
No.
You see, privilege seems so individual and private, and well, I have evidence here that it runs that way when you begin to discuss it.
It wasn't, if I may say, an intention, because as I introduced the notion of privilege, first of all, I'm using it in a non-technical sense in many ways.
Course.
But also I tried to point out that it was very closely associated to the notion of function.
Yes.
You're protecting the performance of the role.
Yeah.
You're protecting the function, so that when I refuse to testify before a committee, the argument in this would be, it isn't that I don't want to incriminate myself, which was the horrible thing about the Fifth Amendment, putting it in personal terms, but that I cannot destroy the functional capacity of my branch of the government by acknowledging your claim to invade its functioning, that is, to violate its privilege. Now, privilege carries with it special privilege, notions of granting and can be taken away, and doesn't bring the responsibility and functional thing, and I'll think of it.
And it raises the question. It raises the question too, Joe, who gives him the privilege?
Well, but this, you see, this comes back. I think one has to say here, I believe in limited government in a sense, but I think such constitutional government is involved is self-restraint. I don't find the restraints present in by adding one other level to the hierarchy of authoritative institutions and saying...
No, but involves prior permanent standing restraints. In fact, that's the meaning of the Constitutional Act, apart from that part of the Constitution, for me, apart from that part of the Constitution which is the arrangement of offices and so on. But the essential Constitutional Act is a standing prepossession against governmental decision as regards some freedoms.
I think not. I think the Essential Government Act is the promulgating of a constitution which creates a body politic.
Well, my point against you is merely rhetorical. If you say function, and we can keep it in mind while we're discussing, I have no objection.
Well, I have sometimes talked about not privilege, but protected, because I think there are the two notions. There's a positive and the negative notion. The positive notion of empowering to investigate, and the other side of it, however, is the protecting against the persons involved against some of the consequences of performing his function, trying to immunize. Well, I'll worry about that.
The little objection that I find in the word is partly what little I understand of the technical sense in the law, whereby it is an exception to an otherwise reasonable rule, is it? And there's no standing duty on your part to do something when you are privileged, but that isn't the essence of it. It is the fact that you are allowed to do something for special reasons which you ordinarily would not be allowed to do. And that connotation of the word privilege seems to me seriously impairs the dignity of the right of free speech.
The long-standing distinction is between privilege and right. Dick? Then Harry?
I want to press this point. For example, to begin with, I think you, this morning, denied something which you had said on Monday, and I think it's important and interesting. Either there's a possible contradiction, or a clarification has been introduced which cuts out some of what was previously said. You gave two sorts of justification for freedom of communication. One was functional, in terms of the effect on the community and its proper legislative function. The other was intrinsic. When you went into the intrinsic good, you said something which I don't think you had been willing to grant before. You granted that the intrinsic value was a partial justification for the freedom, and then you used the notion of immunity of control and used the phrase, when it becomes harmful. Now, whether you intended it or not, once you say that, you're moving more in the direction of the traditional view by noting that there is an intrinsic function to be served through the individual exercise in this case, and that the government, or that the people as a whole, has a right to limit that function when it becomes harmful. Now that's a completely different line, as you recognize, a completely different tone from the remark of saying that the community will grant to the individual that area in which he may first function. You're now saying that there's an intrinsic reason for his functioning, but the community, this is I think the strong point of your remark, the community has a right to specify certain limits to that exercise when that exercise begins to become harmful to the body at large. But that's very different from saying that the community can establish it. Well, will you show
I don't
me
know
how
what
it's
is meant
not?
by community establishing it. To say that certain activities are valued for their own sake, like artistic activity, my argument was this is the case, but this fact does not create any rights.
Well, if it's valuable in itself, how could it fail in... if it's valuable in itself, how could it fail in some sense to create the right to pursue it?
No. Because it is valuable, we create rights to protect it, which protect it. But being valuable does not generate rights by itself.
Well,
to be valuable and to have rights are not identical statements at all.
You may be using the term right so that it's defined in your view within a system. I'll drop the term right.
Well, I find no meaning for it outside
Well,
the
I'll use the term
system.
claim then. If the activity is valuable, why then does the individual not have a claim to pursue the activity?
It's not a legal claim unless it's...
Well, I'm not interested in when it's a legal claim. I'm interested in whether there's a political, moral, or in the final sense, a metaphysical moral claim to it.
Well, I said, one, we give it and value it and encourage it and protect it because it has an important social function. But now you're pushing for another one. What about those people who don't care about that, or the extent to which it's just an intrinsically an activity which people pursue for its own sake, quite apart from its social benefits, if one can think of that? It's just an end in itself and isn't justified.
I don't want to let you go. Wait, I haven't finished on the first point. I think there's something important there. I don't think you ought to be let go that easily on the notion of function, because I pressed you for this on Monday then. When you discuss the notion of function, you're discussing the notion of proper legislation. When I ask you finally to specify what you mean by proper in the proper legislation, I want to see you do that, and I want to see how, as a matter of fact, you relate that proper legislation to the individual ends of the people involved. In short, if you take me to the area where I have to consider the realm of my activity in affecting others, I want to know eventually what the standard is by which I judge whether my effect upon others is good or bad. I think, in other words, that your notion of a function is going to collapse eventually into the notion of intrinsic good, and you're not going to be left with the twofold division you think you're going to be left with, because an appropriate function depends eventually upon the appropriate fulfillment of men. It may be true that I have to consider how I affect others, but what I want from you also is a criterion by which I can know whether I've affected them for ill or good.
Well, I can't give you a criterion of this sort. The whole political process is an attempt to grope towards some conception of what we consider good.
You grope with me then.
Oh, I'll be glad to do that for the rest of my life.
This concludes the recorded part of the third seminar led by Joseph Tussman, Professor of Philosophy at the University of California at Berkeley. Participating in the discussion were the chairman, Robert M. Hutchins, Alexander Mickeljohn, former president of Amherst College, Harry Calvin, Jr. of the University of Chicago Law School, Edwin Dunaway, former Supreme Court Justice of the state of Arkansas, and staff members Richard Lichtman, W.H. Ferry, Harry Ashmore, Harvey Wheeler, and William Gorman. At the fourth and final seminar, Mr. Hutchins will open the discussion by summarizing Mr. Tussman's proposition with a terse caricature offered to illustrate his own dissent.
Mr. Tussman says, I take it, that the norm is silence and the aim is order. That is that really you have to show that you have a privilege to speak in view of your peculiar function or the peculiar circumstances of the time. Now, how would you like to say that the norm is communication and the aim is learning? so that the privilege is a privilege to remain silent under special circumstances rather than to speak. In fact, there is always a moral and sometimes a legal duty to speak. There's a legal duty to get your children ready for communication by sending them to school. There's a legal duty to talk if you're a witness. And the privilege is the privilege against self-incrimination, for example, privilege to remain silent. My question is, doesn't this get you into fewer difficulties, and isn't this more in conformity with the kind of conception of the common good that you entertain than the opposite?
We hope you will join us for the final discussion in this series. This is Halleck Hoffman speaking from the Center for the Study of Democratic Institutions at Santa Barbara.